My client details for you that she has been a stay-at-home mother throughout the course of the 10 to 11-year relationship.
My client does not have the ability to pay. He did encourage wife to work during the marriage.
This court's aware I do represent the respondent and moving party to the motion before you today, Tana Lee. My client is the current wife of the petitioner and the mother to their 3-year-old child, Abigail. My client is requesting the relief in her motion be granted given concerns related to number one, the parenting plan. I think that's kind of where everything originates. Secondary to that are some financial issues that we're asking for the court's direction on as we go through this temporary process until these parties can get on and through the final divorce. Specifically, my client is asking the court largely for the status quo. I would call it the status quo plus as it relates to the parenting plan. My client has traditionally been this child's primary caretaker. Mr. Lee has traditionally been the breadwinner of the family, entrusting my client with not only the care of 3-year-old Abby, but also the care of his 2 older children from a prior relationship, Landon and I believe Jacob. My client details for you that she has been a stay-at-home mother throughout the course of the 10 to 11-year relationship, caring for not only the 2 older children, but more recently, Abigail. Mr. is employed in dual capacity, number one by the Cowlitz County Sheriff's Office, and number 2 as a National Guardsman, giving service at least 1 weekend per month from what we understand. Since these parties separated last October, and again, we're going on a significant period of time, my client details for you that she's had the child upwards of 80%. If you calculate that out, and she provides you calendars and schedules, it actually shows about 83% of the time and overnights the child spent with my client, compared to about 17% to Mr. Mr. Again, we understand generally works a Tuesday through Friday shift to the sheriff's office, and then his National Guard is full weekends, we believe the first weekend of every month. In addition to that, he began a relationship around the holiday season in which he was frequently, or at least 3 weekends of his time, going to Texas to pursue this new romantic partnership with an individual he had met down there, which again takes further time away from him and the child. My client has given you the calendars. Again, we were somewhat surprised on response to learn that Mr. had stated that it's been close to joint. The reality is it hasn't. The reality is his work schedule and his National Guard schedule and his romantic partnership with this other individual has resulted in him not being anywhere near able to have this child 50% of the time. So looking at that, my client has indicated and provided a proposed parenting plan that she believes will not only work for the parties' work schedules, but also promote for this child's best interest, which largely maintains the status quo that these parties have operated under for the better part of the last 8 months or so. My client's also willing to give the Mr. Lee more time. Again, it's not my client's goal to pull back on any of that or to reduce time or make it difficult for him to spend time with his daughter. This little girl loves both parents. Again, that's positive. Now, my client's simply trying to fashion something that works, and we believe we've done that. We are agreeable to Mr. Lee having visitation every second, third, and fourth weekend from Friday to Sunday. We're also agreeable to some kind of visitation, including overnights on that weekend, the week after the weekend in which he's in the National Guard, from a Sunday to Tuesday arrangement. That equates to about 8 to 10 overnights per month. Again, that is more than he's been exercising since October. Gives the child ample time with dad, also recognizes his work schedule, and makes him available for the child. Somewhat of concern is the communication between these parties. We gave you a brief sampling of some of the texts. Now, my client has concern that Mr. Lee, again, is trying to kind of impose his will on this. Concerned most about his financial well-being and his financial best interests as opposed to the best interest of this child. And again, we believe that the parenting plan we have proposed gives ample time and ready time, but also acknowledges that we're dealing with a 3-year-old child who's known only mom as the primary in the primary role. So that's kind of the equalizing or the balancing act we're doing here on the parenting plan. But I think given the circumstances, that makes the most amount of sense and puts this child in a reasonably well position moving forward. If you look at, again, the financial aspect of the parties, this is two folks who are in very disparate circumstances. We did the best we could on our original motion to try to figure out some kind of an income, for Mr. Lee. I think we're pretty close. We have taken his wages based on his bank statements and deposits from the sheriff's office, which leaves, and again, this is net for him, net deposits into his account in the amount of about $7,325 per month. In addition to that, we get the reserve pay, which is another $1,428 per month. Now that puts him at net monthly wages of $8,753. My client, she's employed on a part-time basis, 30 hours or so per week at Roto-Rooter, and makes $20 per hour. Now that leaves her with a gross monthly income of $2,580. I think if you look at child support, that is what it is, based on the incomes, based on the parenting plan. But there's other factors that we're asking you to consider, most notably kind of the standard of living that these parties currently enjoy. While Mr. Lee is living on 30 acres on the Toutle River in Kidd Valley in a custom home, my client and the child are currently residing with her parents in their home in Longview. That can't continue. And we are asking for family support and amount that's reasonable given the circumstances and the traditional roles of these parents, so that she can get out on her own, find suitable housing, which is safe and in a good neighborhood for her and the child. And we think that our suggestion of additional family support, or we can call it maintenance or whatever the court directs, in the amount of $1,261 per month is appropriate, which bumps Mr. Lee's total obligation to $2,500 per month. This still puts him in a superior financial position, especially considering the fact that my client is paying her car payment. And again, we have a complete swearing match. We've provided you information related to that payment, which indicates the tractor which Mr. Lee uses on the acreage up in Kidd Valley, again, is included in that. Again, we were surprised to see where he says, well, the tractor has nothing to do with her car payment, when the information provided, which was fairly simple to acquire, directly refutes that. We've given you not only the text messages related to that, we've also given you the statements from the bank related to that, showing my client's auto payment or auto balance going from $9,000 to roughly $17,000 over the course of the month, acquired at the same time they got this tractor. So again, to suggest that those are two separate issues is not only misleading, but it's blatantly incorrect. Now, we are asking again for the financial relief as cited, also asking for a contribution towards my client's temporary attorney's fees and costs. Again, we're in this situation because these parties are getting a divorce. And again, that's not attributing blame to either side. They just couldn't make it work after a significant period of time. We do believe, based on the disparity of incomes, that's appropriate. My client scratched and clawed to try to come up with those fees that she paid me on the retainer. And we are asking, since discovery will certainly be due, we will need further information related to that home, the retirements and the such. And we are asking that contribution to her fees and costs in the amount of $2,500 be ordered. Also asking that any contribution towards her fees and costs be paid within 60 days of entry of the orders. My client impresses upon me, asking that I impress upon the court, that her primary focus is on this child and making sure that this child has ample time with dad, but maintains the status quo and the recognized pattern of conduct of these people that my client has had the child and been her primary caretaker. And again, our parenting plan certainly prescribes to that notion. Also asking if the court does appoint a guardian ad litem, that be based on the percentage of the incomes off the worksheets, which we have proposed in anticipation of today's hearing.
Thank you, Your Honor. So I think the most important issue in this case to my client is the party's daughter and the parenting plan, and making sure that whatever the court adopts is in the best interest of their daughter. So one area the parties have significant disagreement regarding is what is the status quo, and what has been the status quo since the parties separated. So my client did work full-time during the marriage. However, he indicates that this was not a situation where mother did all the caregiving. My client was involved. He did do a lot of the caregiving. during the marriage, including the nighttime activities as detailed in his response. So since the party separation, my client has had every weekend except for 2 from Friday to Monday. Additionally, my client has just come off a stretch of having the party's daughter for 17 days from June 23rd to July 10th. So this is not a situation where he's had a few weekends since separation. My client has been heavily involved and just had 17 days of parenting time as detailed in our response. In addition to these weekends he's had from December 7th to December 9th and December 15th through December 16th. So this more than makes up for these two weekends, not 3 weekends, that he was in Texas. Mother submits a calendar indicating that these are the dates that my client had the party's daughter. But the calendar is not correct. It does not show all the dates my client had parenting time. To illustrate, her November calendar does not indicate my client had November 10th, and my client submits photo evidence that he had the daughter for an overnight on November 10th. So just on that day, we know that's incorrect. And my client didn't have photos on every day he had the daughter, but he submitted the photos that he does have. Additionally, mother indicates on our calendar that my client, or indicates in her reply declaration, that my client only had their daughter for 5 overnights in June. But even looking at her calendar, we know this is incorrect. My client had much more days than that. So this is not a situation where my client's had a few weekends a month or has not been heavily involved. My client has been heavily involved. He is also the sole caregiver of daughter's siblings, 2 teenage boys. And it's not only is it important for daughter to have a close relationship with both parents, it's important for her to have a close relationship with her siblings. And so we're also asking that the court consider that when putting in place a parenting plan. My client has been very clear regarding his work schedule. Both parties work. Both parties will periodically need daughter when they work, which is normal in most situations. Most parents have to work these days. So my client has appropriate care arrangements, including sometimes a 16-year-old son can provide care, which mother has done as well. So the parenting plan my client proposes gives both parties weekends. It gives both parties time on their day off, and it breaks up the schedule. So mind that this is a 3-year-old daughter, but again, my client just had her for 17 days. So clearly mother is okay with my client having her for long of time. The parties are going through a divorce. My client is, we submitted text messages that show that most of the communications, the vast majority of the communications, my client has been very nice, very respectful, very showing consideration and kindness towards mother, and my client's not indicating mother's doing anything differently. Of course, not all text messages are going to be perfect when parties go through a divorce. So my client is wanting to work with mother and wanting to move forward in an amicable way. One concern that my client is requesting that the court address is whether mother is able to drive right now, and he's not saying that should affect her parenting time or anything like that. But we are asking for parameters around that if she feels like she is not in a place where she is able to drive. She has indicated previously she can't due to some eye surgery, and so we just want to make sure that this is addressed in whatever parenting plan is put in place. Additionally, my client is requesting that the court adopt his proposal regarding support. He has been paying mother $900 since separation. To clarify, $500 was cash and the rest was payment of her expenses. So my client is being completely upfront and fully all information he has with the court. That's what that amount was made of. He has been paying this amount by agreement. Both parties agreed that this was sufficient, and mother never requested any additional support amount until retaining an attorney. So clearly this was enough for her. When ordering support, my client is asking the court to consider that he is essentially the sole financial support for his 2 teenage sons, and he should receive a deviation in child support per RCW 26.19.075. My client does not have the ability to pay wife's requested support amount as demonstrated by his financial declaration. He did encourage wife to work during the marriage, although I recognize that these are temporary orders and this is where we are now. He is proposing, for purposes of calculating child support, mother's income should be imputed full-time at her normal rate of pay. There's no reason she should not be working full-time at this point. He submitted his and all of his tax returns and pay information. We submitted an income calculation. His income is properly counted at a net of $8,049. And again, he's requesting that mother's income be calculated full-time at the current rate of pay. Further, it is impossible to determine what mother's financial need is. Spousal support is based on pay. Mother fails to submit a financial declaration. We don't know what her expenses are. We know she's currently living with her parents and that they have income that's contributing to these expenses, but we don't know exactly what the need is. What we do is based on father's income and his financial declaration, he can't pay the requested amount. I don't know how concerned the court is about the Chrysler payment. Depending on what is ordered in support, the father's asking mother pay that. I think the issue here is the language that mother used in her statement. She indicated the monthly payment was for the tractor and the Chrysler. The monthly payment is only for the Chrysler, but the parties did refinance the Chrysler. So I think that's probably the confusion in the language. My client's not trying to be dishonest with the court. One thing to note is that refinancing the Chrysler to purchase a tractor increased the monthly amounts, the monthly payment by about $68. So that's something for the court to consider, that maybe $68 of that would be due to the refinancing of the tractor, but the remainder was already a payment for the Chrysler. My client is requesting the court deny attorney's fees. He has tried to streamline this process by proposing settlement on temporary orders, proposing mediation, and mother, instead of responding to the offer or agreeing to mediation or something like that, filed this motion. So he really does want to.
Anything that's settlement related, that would certainly go towards that, as would the text message that he provided. But I'll speak to that in a moment. I just asked the court not to consider anything.
I understand. I shouldn't consider negotiations between the parties.
Okay, I apologize, Your Honor. I didn't interpret that as a negotiation, just as a, hey, do you want to go to mediation? So my client is trying to move forward in good faith. He asked that attorney's fees be denied if the court feels it is appropriate to appoint a guardian ad litem. He has no objection to that. He proposes that the costs are equally shared, or at the very least that they on the pro rata percentages in his child support worksheet. Thank you.
Mr. Zandy?
Very briefly, Judge, I want to start by, some of the language that's contained in the declaration seems very contrary to what the statements now are today, almost as it's trying to correct a lot of the misstatements that I would certainly say are contained throughout his responsive pleadings. If you look, and again, by counsel's words, most recently, Mr. Lee had the child for 17 days. Wasn't overnights. Again, I would dispute the fact that that was 17 straight days, and that's not really mentioned anywhere that I see in review of the pleading submitted by Mr. Lee. So again, that's information that I would ask the court not to consider. If you do look at what we do know, even if you throw in the extra overnight on November 10th, as suggested, that bumps him from 3 overnights to 4 for November. That's about 5 in December, 8 in January, 5 in February, 5 in March, which is about the time that he's going to Texas to see the girlfriend. 6 in April, 6 in May, We have the June issue, and then it was most recently in July that he exercised extended visits after being served with this motion and probably in anticipation of today's hearing. Would also state, if you kind of dovetail that and take that into consideration with the text messages, that's concerning. As the court is aware, joint plans require co-parenting, effective communication, both parents having the ability to provide for the child in similar capacities, and we do not have that for Mr. Lee. All of the communications, and I was surprised counsel said they're very nice and very respectful. They're not. It's very threatening. It's very imposing. And the fact that my client asks him on one occasion, thinking that he's going to take the child on his vacation and do something fun, finds out that he actually worked a couple of those days, says, well, where are we leaving the child when you're gone? He says, essentially, it's none of your business. I've got it figured out. So the fact that we have that type of response when she's asking a very basic question shows me that the joint plan being suggested by Mr. Lee just is not going to work based on the circumstances and the significant depth of these two parties currently. But that's a concern. If we look at some of these other suggestions, and again, it stands out that we now have these corrective means. Counsel states, well, he's been paying her the equivalent of $900 per month. That's not what's in his declaration. His declaration, he doubles down on that. He says in two areas, the amount I have been paying since separation. He then goes on and says, I have been paying respondent $900 per month in total support since October. That's not accurate. And again, the same thing with the tractor. We look at that. Counsel says, well, the car was refinanced. Again, that's not what's included in his declaration. He says the loan is only for her vehicle and does not include the tractor. I'm assuming that's tractor because I don't think the parties own a tractor. So again, if we look at the verbiage, we look at the information you do have through the text messages in which he said, essentially, you're going to stipulate to what I want you to. Otherwise, I'm going to do this and that. And the attorneys are going to take all of our money and make all these kind of broad threats. Again, that is not conducive for a joint parenting plan. I think it's safe to assume, based on those communications, based on where we're at, and based on the status quo, he's making the suggestion for a joint plan, not because he wants the time with his child, but more along the lines of he wants to avoid or minimize any financial exposure he has. And it seems very clear through these pleadings to suggest that he's been very nice and very respectful. Again, I didn't read it that way. And I gave you a sampling of what there was related to that. And those are not nice. Those are not respectful. Those are not ones where it says and suggests we can co-parent. Rather, it's ones where it suggests we're going to co-parent and you're going to give me what I want on the parenting plan, or else we're going to go to court. That's not a negotiation. That's a threat. And we have that repeatedly throughout. One last thing I wanted to mention again is that we do need to keep in mind that this is a 3-year-old child. This is a 3-year-old child who has lived a significant chunk of her time since these parties separated in October under a very traditional arrangement of dad getting weekend time with her. And again, my client is agreeable to that. There's been nothing presented that shows she's not going to be willing to accommodate extra time. She wants to do that. But for basis of a parenting plan at this juncture, I think it makes the most amount of sense to give dad his weekends. Hopefully he exercises those. Hopefully he can learn to communicate effectively and in a non-abrasive tone with her, a non-threatening tone, as well as the time in the weeks where he's at National Guard. Again, which everything she suggests in that parenting plan works perfectly to a T with his work schedule between the sheriff's office and the National Guard. Everything else, again, we believe is very reasonable given the financial circumstances, and most importantly, what's best for this 3-year-old child.
Yeah,
Counsel.
I can briefly respond.
Yes, ma'am.
So, Your Honor, I do want to point out first that page 3 of my declaration, or my client's declarations, lines 6 through 8, is when he indicates he had the child from June 23rd to July 10th. So again, this is 17 days. This is not, my client does exercise all of his parenting time. 2 weekends he was out of town, 2 weekends since separation, not a big deal. He made up more of the time by having 17 days of mom's time in addition to another 3 days of mom's time. So my client does exercise his time. To indicate otherwise is frankly pretty insulting. I mean, he submitted pictures showing how involved he is, the activities he does. This is not about finances. He is not a daughter because he wants to reduce his child support obligation. I think that's pretty clear in the pleadings. This is about him wanting to have that time with the daughter and wanting the daughter to have that time with her brothers. So we ask the court to grant our request.
All right, thank you. Well, as is often the case, the parties kind of disagree on a lot of things getting to this point. What is clear is we've got a couple of pretty involved parents. I certainly need to foster the youngest child relationship with her siblings. That's somewhat difficult, less so in the summer, but school's going to start up again here very soon, and then it becomes something of an issue. I'm not going to order anything specific for summer, but I would think the parties need to cooperate to give those boys some time with their sister. For a 14 and 16-year-old, I'm not sure exactly how much they're going to want or how much they'll be able to put up with once you agree to it, but I'll leave that to the parties to work out. I do think the proposal of Friday at 5:30 to Monday at 5:30 makes sense given everybody's schedules. Ms. Lee has, while it's not ideal to be living with her parents, that provides probably some in-home daycare and makes it somewhat easier. So he'll have the Friday at 5:30 to Monday at 5:30, except the weekend where he's in the National Guard, and then he's got Sunday 5:30 to Monday 5:30. As I say, they should cooperate on some additional time with the brothers in the summer. The child support issue, not too much difference of opinion about everybody's incomes, but we do have Mr. Lee providing almost entirely on his own for his two teenagers. And so there should be a deviation for that. There's also the issue of maintenance or family support. I'm going to order total family support of $1,350 per month. That's starting July 15. Fees, $2,000. That should be paid within 90 days. Ms. Lee should be looking for full-time employment. I'm not going to put a specific timeline on that, but I think that's important. I don't see the issues as being ones that a GAL is going to be real helpful on. I think everybody says the other one's a good parent. The only real difference of opinion is that what have we been doing since separation? I don't think a GAL is real helpful in that, so I'm not going to order one at this point. And counsel, given that I'm not here all that often, if there are any issues about the language in the orders, would it be agreeable for everybody just to handle those by way of an email exchange with me, so we don't have to try and set up another hearing that will slow everybody down?
I'd
That's
prefer
fine.
that Ms. Bright Reed's office and my office communicate. I would certainly think pretty well together. I think we could probably get agreed orders out on this, but just in case, yes, we're agreeable to doing that. Any
All right.
remaining issues, email makes sense.
That's
All
fine with me also, Your Honor.
All right, thank you, counsel.
Your Honor, I do, because I know this will be an issue in getting agreed orders. What is Your Honor ordering about the car payment?
At this point, she continues to make it.
Okay. Thank you, Your Honor.
Jackson.
Yeah, I'm sorry. That is leads to the other issue. If that is, we'll fashion something together. If there's any issues on that, that'll probably be one in the email, but I think we can probably sort through that. It's pretty minimal at this point.
All right, thank you.